Every few years Americans are reminded of something uncomfortable about the presidency. The power to pardon federal crimes is nearly absolute. A president can wipe away sentences, erase convictions, or rescue political allies from legal consequences with a single signature. Courts cannot review it, Congress cannot override it, and under the Supreme Court's recent doctrine, a president cannot be criminally prosecuted for any official act, which includes the granting of pardons, even those handed out to donors, cronies, co-conspirators, or individuals whose silence or loyalty might serve the president's interests. This is not a theoretical fear. We have lived through it. Presidents of both parties have issued controversial pardons, but the current administration has pushed the power into territory the framers never imagined: mass pardons, pardons for political allies, pardons issued in the shadow of campaign donations, and pardons granted after overt lobbying by those with direct access to the Oval Office. Each incident reinforces a disturbing truth. If a defendant's greatest threat is federal prosecution, then the president becomes the most valuable person in the criminal justice system, someone who cannot be held to account for granting clemency in ways that would land any other official under indictment. So the public asks the obvious question: isn't there any way to eliminate this risk entirely? If the presidential pardon can shield the powerful from consequences, if it can be bought, traded, or strategically deployed, why must so many serious crimes be federal in the first place? Why should the entire nation's system of accountability hinge on the discretion of one person? And here is where the constitutional reality becomes unexpectedly helpful, because the truth is not only that there might be a way to eliminate the risk, it is that the Constitution itself already built that way into the system. The framers never intended the federal government to control most criminal prosecutions. They were deeply skeptical of centralized prosecutorial power. They assumed the states, not the federal government, would be the principal guardians of criminal justice. And they designed the pardon power to apply only to federal offenses because they never expected federal criminal law to grow beyond a few limited domains. In other words, the apparent crisis we face today, the abuse of an unchecked federal pardon power, is the result not of constitutional defect, but of constitutional drift. The federal government assumed criminal authority it was never meant to have, and now the most dangerous feature of that expansion is becoming impossible to ignore. Which brings us to the thesis of the argument that follows. If the federal government lacks both constitutional grounding and functional competence in criminal prosecution, and if the presidential pardon power exposes the entire federal scheme to corruption, then returning criminal jurisdiction to the states is not a radical idea. It is a restoration of the constitutional design. What follows is the case for that restoration. When the Constitution was drafted and ratified, federal criminal law was intentionally narrow. The founders enumerated only a handful of offenses that the national government could prosecute: treason, piracy, and felonies on the high seas, counterfeiting, offenses against the law of nations, and crimes committed on federal property such as forts, dockyards, and federal enclaves. That list was not the product of oversight. It reflected a conscious design decision grounded in the political philosophy of the era. In an age scarred by centralized British authority, the framers believed that criminal law, enforcement of moral norms, public safety, and local order belonged primarily to the states. Madison's description in Federalist No. 45 is really unambiguous. The powers delegated to the federal government are, quote, few and defined, while those remaining with the states are numerous and indefinite. Now, indefinite in 18th century political vocabulary referred specifically to the police power, the authority to regulate health, safety, welfare, and morals. Criminal law was the quintessential example. Jefferson, Wilson, and even Hamilton recognized this. Hamilton, who was probably the most pro-federal of the founders, never suggested granting Congress a general power to define and punish crime. He defended national authority over foreign relations, commerce, and finance, not local wrongdoing. No one imagined the federal government addressing assault in Ohio, burglary in Florida, or election fraud in Arizona. These tasks belonged to state magistrates, sheriffs, and juries, not to a distant national government. The clearest evidence of this original design is the absence of any federal police power in the text. Unlike the states, the federal government has no general authority to legislate for public safety or criminal justice, As Chief Justice John Marshall later emphasized in McCulloch v. Maryland, Congress may enact laws necessary to execute its enumerated powers, but it does not possess the full, indefinite regulatory authority that the states hold by default. The founders understood this distinction clearly, and the constitutional structure reflects it. The limited criminal jurisdiction of the early republic was a feature, not a flaw. The modern Department of Justice, created in 1870, bears little resemblance to the founders' expectations. Its present criminal jurisdiction isn't derived from the constitutional text, but from a century of doctrinal expansion by Congress and the courts. Today's federal criminal code, thousands of pages, encompassing everything from drug offenses to tax evasion to environmental regulations, rests not on enumerated powers, but on interpretations of the Commerce Clause and the necessary and proper clause that would have been unrecognizable to the founders. The Commerce Clause is the primary vehicle for this expansion. Beginning in the late 19th century and accelerating during the New Deal era, courts held that Congress could criminalize activities that affect interstate commerce, even if only indirectly. This kind of elasticity allowed Congress to federalize drug crimes, firearm possession, and a vast array of financial and corporate misconduct. These days, the modern doctrine often requires only a pretty tenuous connection, sometimes as slight as a component manufactured out of state or a communication sent across state lines, to transform a state offense into a federal one. The necessary and proper clause, which was originally understood as a tool for executing enumerated powers, eventually became a justification for nationalizing entire categories of criminal law whenever Congress identified a federal interest. Yet, even the broadest early interpreters of federal power warned against this outcome. Marshall's McCulloch opinion, though famous for its embrace of implied powers, explicitly distinguished between legitimate national functions and general police authority. Jefferson inveighed repeatedly against the expansion of federal criminal law beyond its textual limits, especially during the Alien and Sedition Acts episode, which he saw as proof that the federal government really couldn't be trusted to wield criminal authority broadly. The founders would therefore view the modern federal criminal apparatus not as an evolution, but as a departure, an accretion of statutes, doctrines, and bureaucratic habit layered on top of a constitutional structure that never actually authorized such breadth. In this context, the Department of Justice's present dysfunction, procedural errors, invalid appointments, mass attrition, and declining prosecutorial capacity takes on a different significance. It's not merely a logistical failure or just a temporary managerial breakdown. Instead, it's a moment in which the constitutional architecture is revealing its underlying logic. Because federal criminal authority rests on doctrine rather than constitutional command, its legitimacy depends heavily on professional competence and institutional stability. When that competence erodes, the fragility of the federal criminal enterprise really becomes apparent. The recent dismissal of the Comey and James prosecutions is a case in point. The indictments did not collapse because of a controversial legal argument or evidentiary dispute. They collapsed because the Department of Justice failed to appoint a prosecutor lawfully, mishandled grand jury procedures, and filed charges at the brink of the statute of limitations, a deadline it ultimately missed. These are not close judgments or unforeseeable mistakes. They are the most basic failures a prosecutorial office can commit. Combined with the depletion of entire divisions, the Civil Rights Division, the Voting Section, and the Public Integrity Section, these failures demonstrate a loss not only of capacity, but of structural integrity. When an institution that was never constitutionally guaranteed begins to lose the practical ability to perform its adopted role, the constitutional fallback becomes visible. The framers designed a system in which the states bear primary responsibility for criminal justice. The rise of the Department of Justice represented a functional deviation. Its weakening represents a return to the default. The contemporary crisis is therefore not an aberration, but a reversion, an institutional reset toward what the Constitution, by design, always meant to be the baseline. Arguments against devolving criminal authority to the states often take the form of slippery slope predictions, that corruption will go unpunished, that interstate drug networks will flourish, or that civil rights violations will be ignored in jurisdictions unsympathetic to them. These concerns are real, and the founders confronted them openly, yet they still opted for state primacy in criminal matters. Their writings show why. The alternative, a centralized national prosecutor, was considered a greater structural danger than uneven state enforcement. Madison and Jefferson in particular warned that a federal government with a general criminal jurisdiction would wield disproportionate power, easily turned toward political ends. They feared a federal prosecutor capable of dictating local justice, independent of local juries and local norms. Their remedy was not to deny federal authority entirely, but to circumscribe it to national functions, treaties, foreign affairs, interstate commerce in its narrow original sense, and crimes against the federal government itself. Everything else, they believed, would be better handled by institutions close to the people, accountable through local elections, and constrained by local constitutional traditions. The present condition of the DOJ, a sprawling bureaucratically insulated agency capable of targeting individuals nationwide, yet unable to meet basic professional standards, illustrates the very dynamic the founders feared. The collapse of high-profile prosecutions because of elementary procedural blunders is not simply embarrassing, it demonstrates the structural risks of entrusting broad criminal power to a distant national bureaucracy. For the founders, the remedy to such a scenario was clear. Prosecution belongs at home, in the states, unless national sovereignty is directly implicated. Given this historical and constitutional context, reconsidering the scope of federal criminal prosecution is not a radical project, it is the most conservative, original meaning consistent response to the DOJ's crisis. The Constitution presumes that states handle nearly all crime. The federal role exists only where the national government's enumerated powers require it. When the DOJ exercises authority outside those boundaries, and does so incompetently, it does more than fail administratively. It trespasses constitutionally. Restoring criminal authority to the states would not dismantle the federal government's legitimate functions. Treason, piracy, counterfeiting, national security offenses, and crimes involving foreign nations would remain federal, as they were always meant to. But the routine criminal docket, the vast sea of fraud cases, street-level drug prosecutions, election enforcement, and regulatory crimes would return to the sovereigns who were constitutionally entrusted with them. In that sense, devolving criminal jurisdiction is not innovation but restoration. It aligns our practice with our founding design, reins in federal overreach, and re-anchors the justice system in institutions that are locally accountable and constitutionally empowered. In a moment when the DOJ's failures can no longer be ignored, the path forward may lie not in reconstructing an overextended federal prosecutor's office, but in returning to the structure the framers intended, one where the states, not Washington, are the primary guardians of criminal justice. For decades, we mistook complexity for wisdom. We built layers of federal criminal law atop a foundation that was never designed to bear their weight. We allowed urgency, politics, and convenience to expand federal authority beyond its constitutional shape. And now we're surprised that the structure is cracking, but the cracks are not the failure, they are the signal. They tell us what the founders already knew, that a single distant government cannot, and should not, be the primary engine of criminal justice for a continental republic of diverse communities. The presidential pardon power is not a glitch, it is a feature of a system that assumed federal criminal law would be rare. The DOJ's procedural collapses are not isolated failures, they are symptoms of a structure pushed beyond its design. The erosion of trust is not just about performance, it is about legitimacy. And legitimacy cannot be restored by memo, or by public relations, or by yet another Inspector General report. It can only be restored by returning power to its constitutional origin. Let the states resume their rightful place. Let local juries, local prosecutors, and local laws bear the burden they were always meant to carry. Let the federal government return to its enumerated realm, where piracy, treason, and crimes of genuine national concern still rightly belong. Because when prosecution depends on one man's signature, when justice can be undone by loyalty, lobbying, or campaign cash, when our safeguards amount to tradition rather than law, we are not living in a system of checks and balances. We are living on borrowed legitimacy. The solution is not to reform the DOJ. The solution is to release it from a role the Constitution never assigned it. The question is not whether the states are perfect. The question is who was meant to govern crime in a republic built on divided power. And the answer, utterly clear from text to tradition, is this: The power to prosecute must reside where the power to pardon does not. Federal judges are not powerless in the face of an overgrown federal criminal apparatus. They sit at the boundary between constitutional authority and statutory overreach, and although they cannot rewrite Congress's criminal code, they are obligated to ensure that any prosecution before them rests on actual constitutional grounding, not merely on decades of doctrinal drift. Judges can and should evaluate whether the charged offense genuinely arises under an enumerated federal power. They can demand that the government articulate the precise constitutional basis for its prosecution, not simply cite the Commerce Clause as a talisman. When a case rests on attenuated theories of interstate effects, expansive readings of federal interests, or prosecutorial creativity that would have been unrecognizable to the framers, a federal court has the authority to dismiss. The judge need not wait for the merits phase. A Rule 12b(3) motion, challenging the government's power to prosecute, goes to the heart of subject matter jurisdiction and the Constitution itself. The federal judiciary has already accepted this responsibility in other contexts. Courts routinely dismiss charges where Congress exceeds its commerce power, where statutes conflict with constitutional text, or where federal encroachment overwhelms state sovereignty. The same analysis applies here. If the DOJ brings a case that is federal in name but not in constitutional pedigree, a federal judge can, and under the oath to uphold the Constitution, must stop the case before trial. The power to halt a prosecution lacking constitutional foundation is neither radical nor discretionary. It is the judicial branch performing the function the framers assigned it, policing the boundaries of federal authority. If federal judges are the guardians of constitutional structure, grand jurors are the guardians of constitutional legitimacy. Unlike prosecutors, they are not part of the executive branch. Unlike judges, they are not constrained to apply binding precedent even when it diverges from original constitutional meaning. Grand juries are the one institution where the people themselves participate directly in federal criminal power, and the framers designed them to operate independently, free to evaluate not only evidence, but the propriety of the prosecution itself. A grand jury is never required to indict simply because a federal statute exists, or because a prosecutor claims jurisdiction. Jurors may examine whether the alleged crime truly implicates a federal interest the Constitution was meant to protect. If the conduct looks like a local offense, the states are equipped and constitutionally empowered to handle. Jurors can refuse to approve a federal charge. If the prosecution depends on an expansive theory of federal authority that would have shocked or angered the founders, jurors may conclude that the case belongs in state court, not federal court. The power of refusal is absolute. A no bill cannot be appealed, overturned, or compelled. And exercising this authority does not require ideology, confrontation, or legal sophistication, merely civic judgment. Any citizen seated on a grand jury can ask, is this really a federal crime, or is it something the Constitution left to the states? If the answer is the latter, the grand jury is entitled to say no, and, crucially, that refusal eliminates the risk of presidential pardon abuse, because a case that never becomes a federal prosecution never becomes vulnerable to presidential clemency. No change in law or regulation, no election, no political actor at all is needed to implement the proposal. Only citizens who care enough about their country to save it.